our people. Now, this paper is extraordinarily rich. In fact, it will show you the in-depth research undertaken by my brother, a very distinguished, but yet very humble judicial officer. I told you, you have to be humble. You will see in the presenter of this paper a distinguished, but very humble judicial officer. He is ahead of court. Some of you must be praying for the day you will hear the court. Yeah, you already have somebody who is going to talk with you. He's an head of court. Very erudite scholar. Your worships and your honors. Look, you could not have wished for a more perfect resource person to handle this very crucial legal discourse. I thought I would see some hands clapping now for our presenter. Yeah, I will still take time to invite him up there. Now, the topic is going to talk about repositioning the judiciary for better justice delivery. Honestly, I consider myself privileged. And why am I privileged? Thanks to the administrator of the National Judicial Institute and all the directing minds of the institute and the staff. You know, they remembered me that I need to be to take part in this wonderful discourse. And that is why I'm here today to listen. And do you know the other thing I want to do? To learn. To learn at the foot of this great man. A legal mind that I have known for a long time, over 2 decades. What does that tell you before he gets to speak? Keep your friends as you come here. Network. Don't come and only listen and then you go. Network. I've known my Lord for over 20 years. We met in one of this kind of workshop. Network. Don't be an island. You don't even know the day one of your colleagues will mention your name to somewhere very important and you will be upstairs there. So find time to network. Please, it is on this basis I want us to welcome His Lordship, the Honorable Justice Cosmas. His middle name, luckily I'm not in Makurdi, so I'll try to pronounce it. But if I fail, I already asked for permission. Andoasia, I don't know. The ending of the name is S-E-E-R. Is that not a Sia? I told you you are having a man who is erudite, and even his name shows he has come to reveal the truth of this topic for you. And then his surname is Ide. My Lord is the president of the Benue State Customary Court of Appeal, Makurdi. He holds the distinguished national honor of the officer of the Federal Republic. And even in religious wise, my Lord is a knight. And so I present to you, and interestingly, what a coincidence it is. The presenter and myself, we all came in from Makurdi. Wow, it's such an honor. We all came in from Makurdi. He, the president of the Customary Court of Appeal of Benue State, I, the presiding justice of the Court of Appeal, Makurdi Division. My Lord, the President, you are welcome to Abuja. You know, Benue is the food basket of the nation. So since I was posted there, I don't have problem with food again. Thank him for me. As I welcome him, my Lord, you can now take the floor, present these papers to these ones, and I assure you your worship and your honor, by the time he concludes, we will have enough to discuss, to dissect, understand, and appreciate this great man. Thank you, my Lord, the President.
My Lord, the Chairman of Session, the Lord's heads of courts here present, staff of the NJI, your worships and honors, participants at this conference, ladies and gentlemen. When I got the invitation to present this paper at this conference, it was stated therein that my Lord Justice George, presiding justice of the Court of Appeal Makurdi Division, is going to chair the session. As he has already told you, we are both in Makurdi. Appeal is from my court, that's the customary court of appeal. Go to his court. So I said, wow, these people in the NJI want the judge to come and sit and appeal over my paper. Because recently, one of my judges drew my attention to one of the decisions we passed, which went to his court. And our judgment was overturned. We set aside our decision. It was on an issue of jurisdiction, because you know that the jurisdiction of the Customary Court of Appeal is very narrow. We have been fighting tooth and nail to have the jurisdiction enlarged by constitutional amendment. We have not succeeded. We are hopeful that very soon that will come to pass. So our decision was set aside. I hope, my Lord the Chairman, you will not overturn my paper. I consider it a great honor and privilege to have been given this opportunity to share my thoughts on this very important topic, which is at the core of the mandate of the judiciary. With this esteemed gathering of judges of the lower courts from all over the Federation. I extend my sincere gratitude to the Board of Governors of the National Judicial Institute, under the esteemed chairmanship of the Honorable the Chief Justice of Nigeria, Honorable Justice Kudirat Kekere Ekun, TCON, and also to the administrator of the Institute, Honorable Justice Salisu Garba Abdullahi, as well as the management team for the invitation extended to me. The topic I've been assigned to present a paper on is repositioning the judiciary for better justice delivery. The scope of the paper is obviously very wide. With the time allotted, it will not be possible to cover the topic exhaustively in this paper. We, therefore, only set the ball rolling by highlighting some salient aspects, as it will make more sense if the time available is spent as an interactive session rather than one for academic discourse. It is my hope that the insights shared in this paper will inspire a robust discourse on the need to reposition the judiciary for better performance, most especially at the lower cost level, and foster more dedication and passion by the participants to the ultimate goal of making the judiciary to truly reflect its passion as the last hope of the common man. The paper aims to explore the critical role the lower courts play in the Nigerian judicial system. It will examine key challenges and the reforms needed to ensure their effectiveness. It will also discuss how strengthening the capacity of these courts can uphold the rule of law and contribute to the broader objective of repositioning the judiciary for better justice delivery in line with the theme of the conference, which is strengthening justice, upholding the rule of law, the role of lower courts in the judicial system. I have highlighted the roles the judiciary play in the society, which are very important roles. However, like many other institutions, it faces significant challenges that hamper its ability to dispense justice effectively and uphold the rule of law. In order to achieve better justice delivery, it is imperative to reposition the judiciary and address these systemic issues. As Lord Denning once observed, and I quote, "The proper role of the judiciary is to secure that the rules are observed, that justice is done, and that the law is upheld." End quote. The role of the lower courts in the Nigerian judicial system. The lower courts in Nigeria, which include the magistrate courts, customary courts, Sharia courts, and area courts, are the most accessible courts to ordinary citizens. The courts and the judges that man them are closest to the grassroots and are found not only in rural areas, but also in urban areas of the country, where in most cases, higher courts are not located. All magistrates are lawyers. In some area, Sharia and customary court judges are non-lawyers. About 80% of cases filed in our courts are handled in this court. They are relatively cheaper in terms of cost of litigation, closer to the people geographically, and handle a majority of the legal disputes in the country. They serve as the first point of contact for many citizens within the justice system, thus playing a crucial role in maintaining social order. Despite their critical role, the lower courts in Nigeria face numerous challenges that hinder their ability to effectively deliver justice. These include corruption, lack of adequate resources, and delays in case handling. Furthermore, lower court judges and magistrates are often inadequately trained and face significant external pressures, such as political interference and corruption. Addressing these issues is essential for repositioning the judiciary and ensuring that the rule of law is upheld. Challenges facing the Nigerian lower courts. Delays in court proceedings, case backlog. One of the biggest problems in lower courts is a delay in resolving cases. Many cases stay in court for years, even though they could be decided quickly. The old adage, justice delayed is justice denied, is particularly relevant in the Nigerian context, why cases can languish in the docket for years without resolution. In Johnson and Agnew, Lord Diplock emphasized the importance of timely justice, noting that, and I quote him, "The law should be administered in a manner which is expeditious and efficient. Delay in the legal process brings the law into disrepute," end of quote. In the lower courts, these delays can be due to different reasons, such as not enough judges or magistrates, frequent adjournments, outdated case management systems, and inefficiencies in court procedures. The number of cases waiting to be heard in lower courts continues to increase, leading to a backlog. This problem is especially serious in areas with high population density. With more cases coming in every day and fewer resources to handle them, it becomes impossible for courts to catch up. This backlog of cases further leads to delays. These delays can frustrate people seeking justice, especially those with urgent matters. When justice is delayed, it makes the courts less effective and weakens people's confidence in the judicial system. A classic case of delay in our court system is exemplified by the case of Amadi against NNPC, where the Supreme Court, in deciding on a preliminary issue of jurisdiction, which took a period of 13 years, had this to say, and I quote, "Finally, this appeal succeeds, and it must be allowed. The checkered history of this case once more brings to light the dilatory effect of interlocutory appeal on the substantive suit between parties. The action in this case was brought on the 29th day of April 1987. The motion on notice to strike out the case for want of jurisdiction is dated 15th day of April 1988. That is about a year after the suit was filed. The ruling of the High Court was delivered on the 20th day of May 1988. The appeal against the ruling was delivered by the Court of Appeal on the 16th day of February 1999. The final judgment in the interlocutory appeal is delivered today by this court. It has thus taken 13 years for the case to reach this stage. With the sources of the plaintiff's appeal before us, the case is to be sent back to the High Court to be determined, hopefully on its merits, after a delay of 13 years. Surely, this could have been ended idea being that the point was taken in the course of the proceedings in the substantive claim to enable any aggrieved party to appeal on both the issue of jurisdiction and the judgment or merit in the proceedings as the case might be. I believe that counsel owe it as a duty to the court to help reduce the period of delay in determining cases in our courts by avoiding unnecessary preliminary objections as the one here, so that the adage, justice delayed is justice denied, may cease to apply to the proceedings in our courts. If cases are decided fast, it will certainly enhance effectiveness in the justice sector and boost confidence of the citizenry in the courts as the last hope of the common man. End of quote. On this note, I will enjoin you, the lower court judges, as it happens in the Superior Court, that when some preliminary objections are taken in the course of proceedings, take the objection, but go ahead and take the case. Deliver the ruling when you are delivering the final judgment in the case, so that you don't waste too much time. Any person who feels aggrieved or is aggrieved by your ruling or judgment can then appeal on both issues to the court of appeal. That will hasten the quick disposal of cases. It does behove on judges to be strict with requests for adjournments. Many of the requests for adjournments, especially in the lower courts, are premised on flimsy excuses. The admonition by the Supreme Court in the case of Banner against Telepower Nigeria Limited by Mukhtar JSC, as it then was, is apt. And I quote, "No litigant should be allowed to take a court to ransom. It is evoked for the public to attack courts on delays of cases in court. When unknown to the generality of the public, the fault does not lie on the courts alone. The litigants and lawyers alone share in this snare case of litigation. The instant case is the locus classicus, and it behoves courts to discourage this unwholesome behavior and frown on them." End of quote. Lack of adequate resources and infrastructure. Lower courts often operate with limited resources, which makes it difficult for them to function properly. Courts are often dilapidated. Judges lack essential legal materials, and basic amenities such as electricity and internet access are most times unavailable. It should be emphasized that judges of the lower bench play a crucial role in ensuring effective administration of justice and upholding the rule of law. They preside over a wide range of cases from civil disputes to criminal trials, and their decisions have a significant impact on the lives of individuals and communities. Given the importance of their role, it is essential that they are provided with the necessary resources to carry out their duties effectively. As noted by Honorable Justice Muhammad West, the former Chief Justice of Nigeria, quoting, "Without proper infrastructure and adequate resources, no judicial system can function effectively. The environment in which justice is dispensed must reflect the importance of the task being undertaken." End of quote. The common problems here include poor infrastructure, lack of legal materials, low salaries and allowances, training and capacity building. The need for continuous legal education and capacity building for judicial officers cannot be overstated. Many lower court judges and magistrates in Nigeria lack the necessary training to handle the complex legal issues that often arise in their courts. This is especially problematic given the rapidly evolving nature of law, which requires judges to be well-versed in areas such as human rights, alternative dispute resolution, and the use of technology in legal proceedings. Lord Bingham, in his seminal work, The Rule of Law, stressed that, and I quote, "Judges must be well educated in the law and its development. Without ongoing training and capacity building, judges risk being unable to meet the demands of a changing legal landscape," close quote. In Nigeria, investment in judicial education is crucial to ensuring that lower court judges can perform their roles effectively. In this regard, the advice provided by Alhaji Abdullahi Ibrahim, SN, former Attorney General of the Federation, is apt. And I quote him, "There is need for constant retraining of members of the judiciary. In this connection, the judiciary should reach out beyond the narrow confines of listening to itself and its members to wider sources, even if this comprises young persons, so long as they have appropriate knowledge to impart. Law is today taking on a much wider dimension. Many developments that transcend the basic traditional law subjects have become intertwined with the law. The judiciary is expected to deliver justice within this modern milieu. These developments will not wait for any reactionary persons to decide whether or not they want to catch up. End of quote. Corruption in the lower courts. Corruption is another major issue that affects lower courts. Some judicial officers or court staff might take bribes to influence the outcome of cases. This corrupt practice makes it difficult for the courts to deliver fair judgments. When people can pay to get favorable decisions, it undermines the rule of law and makes it hard for ordinary people to get justice. Corruption leads to a situation where only the rich or powerful can win cases, regardless of the truth or fairness of their claims. Corruption has permeated virtually all facets of our national life, including the law courts or the judiciary, and it is a major obstacle to justice delivery in Nigeria, particularly in the lower courts. It erodes public confidence in the judiciary and undermines the rule of law. Lord Denning cautioned us, quoting, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking the judge was biased," close quote. The perception that justice can be bought or influenced significantly undermines the integrity of the judicial system. However, this menace still thrives on a larger scale in the lower courts because lower court judges and magistrates often work in environments where they are poorly remunerated and lack sufficient institutional support, making them more susceptible to corruption. I have given some instances of how corruption manifests in the lower courts, especially pertaining to the role of beliefs. Advised that we should watch them very properly. A renowned constitutional lawyer, Professor Ite Sage, once noted that a judiciary plagued by corruption cannot discharge its duties effectively. It loses its independence and becomes a tool for oppression rather than a guardian of justice. In a similar vein, Honorable Justice C. Oputa also condemned the malady and stigma of corruption in the judiciary and spoke of canons of rectitude in judicial conduct for judges, which I find compelling to quote in extenso. She said, and I quote, "Corruption is a cancer eating deep into every facet of our national life. The courts have not been spared. But to retain confidence in the system, the administration of justice in our courts should, above all things else, be pure, incorruptible, and just. Otherwise, we dispense the counterfeit. Justice in our courts should never become a marketable commodity blatantly auctioned, with the hammer going down to the highest bidder. Such an auction sale of justice defaces, disfigures, and debases the beautiful effigy of elegant and relentless justice. Our judges should, at all costs, ensure that in our courts, justice is not mocked, not depreciated, not diluted, not disfigured, not prostituted, nor in any way debased. This should be the stuff of which and from which our people's confidence in the court system should be made." End of quote. Honorable Justice Samson Waifo could not have been more poignant on his description of a corrupt judge when he stated, quote, "A corrupt judge is more harmful to the society than a man who runs amok with a dagger in a crowded street. He can be restrained physically, but a corrupt judge deliberately destroys the moral foundation of society and causes incalculable distress to individuals through abusing his office. While still being referred to as honorable, it is difficult to bring him to account under our system. No judge worth the name should feel inclined to hide any positive element of his head in the closet through fear or favor, or from corrupt motives or simply on grounds of intellectual compromise when reaching a decision. He must, to the best of his ability, act as God's nominated agent. End of quote. The Guardian newspaper, in an editorial in October 2002, titled Cleansing the Judiciary, was very explicit in its judgment against corrupt judges, where it wrote, quote, "For the judiciary to appear truly in our eyes and consciousness as a passion of hope for the common man, those who administer justice must be squarely clean. They will always be human, all right, but the peculiar demands of their jobs require that they overcome most of human foibles. Those who cannot or are unwilling to should be eased out to maintain the sanity of the temple and to reassure all who seek justice that they will be dealt with by honest ministers." Close quote. How these challenges affect justice delivery? All these challenges combined make it hard for lower courts to deliver justice effectively. When people experience long delays, corrupt practices, or poorly maintained court facilities, they lose faith in the judicial system. For people in rural or undesired communities, where lower courts are often the only courts available, these challenges mean that justice becomes inaccessible. The rule of law is weakened when the courts cannot function properly. This threatens peace, security, and order in society. In summary, these issues not only slow down the judicial process, but make it unfair. The courts need to be strengthened with better resources, proper oversight to curb corruption, and more judicial officers to reduce the delays and backlog. This will help improve justice delivery and restore people's confidence in the lower courts. All of us are aware of the common cliche now of go to court. When anything happens, they say go to court. And this is very derogatory because it means that when you go to court, there will be no justice. So we all have to be very mindful of that. Suggestions for reforms. Strengthening judicial independence. One of the most critical reforms needed is the strengthening of judicial independence. Judicial officers must be free from external influences such as political interference or pressure from powerful individuals to deliver impartial justice. As Lord Phillips or Waldemar Travers once observed, judicial independence is the cornerstone of the rule of law. Without it, there can be no justice. Talking about judicial independence, it is apposite to comment on the ongoing exercise seeking to alter the provisions of the Constitution. There is presently a bill before the National Assembly seeking to alter the provisions of the Constitution by transferring the powers of the National Judicial Council, NJC, to appoint or remove judges of state courts and relocate them to the state governors, and also transfer the responsibility for managing the funds of the state judiciaries to states by amendment of sections 271, subsections 1, 2, and 5, 276, subsections 1, 2, and 5, 281, subsections 1, 2, and 5, and paragraph 21 of part 1 of the third schedule, and paragraph 6 of part 2 of the third schedule to the Constitution. The hallowed principle of judicial independence encompasses appointment and removal, remuneration, and security of tenure of judges. It also includes insulation of freedom from unwarranted interferences with the judicial process by the executive arm of government or politicians. To say the least, the bill is absolutist in intent, a subterfuge capable of shredding and utterly destroying the fabrics of separation of powers and judicial independence in the states of the Federation of Nigeria. If allowed to see the light of day, the state governor will ultimately transform into a behemoth capable of devouring anyone at his whims and caprices. Considering that in our real body politic, the doctrine of separation of powers is observed in states, mostly in breach, removing the power to appoint and remove judicial officers from the detached, a political and non-partisan entity like the NJC should not even be contemplated, as it will spare doom for the judiciary, nay, the country. In Nigeria, Judicial independence can be enhanced by ensuring that judges and magistrates are appointed through a transparent and merit-based process. Additionally, the judiciary should have greater financial autonomy, allowing it to operate without reliance on the executive for funding. This will significantly reduce the potential for external influence or interference and ensure that judicial officers can perform their duties without fear or favor, affection, or ill will. You will see that the participants here are not many. This is just because some of the states, they could not sponsor their judges to come. It's not as if they don't have judges. But the funds for the judiciary to sponsor some of your colleagues to come here are just not there. While clamoring for judicial independence, we should have a bear in mind the admonition of Honorable Justice Biobole George just here, that is the chairman of this paper, which I consider apt, and he stated thus: judicial independence must not be mistaken neither for judicial rascality, nor for mere boastfulness of the powers of our judgments and orders, nor of financial autonomy only, but in the pure, unhindered, and unadulterated dispensation of justice to the peoples of Nigeria without fear or favor, ill will or affection. This is what, to me, true judicial independence entails. Thus, a financial poor but courageously sound judge can still be independent in his thought and deliverer of justice to the peoples of Nigeria. Indeed, no country, going by the near deity work of a judge, as representative, as it were, of the God of justice on earth, can fully and adequately remunerate judges. This is so because due dispensation of real justice is not quantifiable in terms of naira and kobo. End of quote. The role of technology and welfare. Incorporating technology into court processes can greatly improve the efficiency and accessibility of lower courts. For instance, the use of electronic case management system can help track cases and reduce paperwork, making it easier for judges and court staff to manage their workloads. Video conferencing technology can also be used to hear cases remotely, reducing the need for people to travel long distances to attend court. Digital records and online filing system can help improve transparency and reduce delays in processing cases. By embracing modern technology, lower courts can provide better services and reduce the administrative burden on judicial officers. In addition to physical infrastructure, the judiciary must also have access to sufficient financial resources to operate effectively. Judicial officers must be properly remunerated to reduce the temptation for corruption. What the recent enhancement in the salary and other welfare packages for judicial officers or superior courts on record is a welcome development and can go a long way in curbing incidences of corruption at that level. Remuneration of judges on lower courts has remained abysmally low and needs to be expeditiously improved to reduce the propensity for temptation towards corruption. In Benue State, the government recently put in place the Enhanced Retirement of Magistrates and Law Officers Law 2024. The said law has increased the retirement age of magistrates and law officers in the state from 60 to 65 years, and also provided welfare packages for them. Of course, this includes cheerful driving cars for our lower court judges. The law is yet to become fully operational. This is indeed a welcome development. Other states are called upon to emulate this gesture. I understand that states like Kwara, Kogi, and Kano have also have similar laws in place. It is further suggested that the Constitution be altered to expand the meaning of judicial office as set out in Section 318, subsection 1, Part 4 thereof, to include the office of magistrate and judge or lower courts who are lawyers. In this wise, their salaries and allowances should be a charge on the Consolidated Revenue Fund and taken over by the National Judicial Council, as is the case with judges of the Superior Courts on record. Enhancing training and capacity building. Regular training is necessary for judicial officers to stay updated on the latest legal developments and improve their skills in handling complex cases. Ongoing professional development programs should be organized for judges and court staff to ensure they are well equipped to handle the demands of their roles. This training should focus on areas such as legal ethics, human rights, and emerging trends in law, such as the application of technology in court processes. As Professor Yemi Osinbajo, the former Vice President of Nigeria, remarked, I quote him, "Continuous training and development of judicial officers is crucial for ensuring that the judiciary remains responsive to the needs of society. Without adequate training, judges may struggle to adapt to the rapidly changing legal landscape." Close quote. The courts should also be regularly provided with adequate materials and tools necessary for the efficient administration of justice. The National Judicial Institute is designed to be a coordinating body for legal training. It is doing very well, though there is still room for improvement. Further, the functions of the NJI should not preclude individual state judiciaries from organizing additional training for their judges and support staff. Additionally, legal reforms that simplify court procedures and eliminate outdated practices can help make lower courts more efficient. The introduction of alternative dispute resolution, ADR mechanisms, like mediation and arbitration, can help reduce the number of cases that go to trial, allowing for quicker and less formal resolutions. There is no doubt that ADR has assumed center stage as a dispute resolution mechanism. The concept simply means that other means of resolving disputes besides the court be employed. The courts are the primary forum for dispute resolution. Nevertheless, they have become inundated with an enormous dispute profile arising from an increased volume of domestic and international commerce, more so that the world has now become a global village. The challenges brought about by these developments are enormous, and the human and material resources to smartly and expeditiously determine all disputes without a reference to some form of compromise resolution method expressed in ADR mechanism are lacking. The compromise demands that the employment of flexible rules devoid of technicalities in the attainment of timely dispute resolution. In the early stages of arbitration, the regular courts were reluctant to accord recognition to the decision or awards of arbitrators. This attitude flowed substantially from a reasoning that arbitration constituted a rival body to a regular court. However, it was soon realized that arbitration may in fact prove the best way of settling some types of disputes. Thus, the attitude of the regular courts to arbitration gradually changed. ADR mechanism has come to partner with the courts, and there is no reason for the courts not to embrace it in their case flow management as a dependable ally in the case to unload some of the heavy workload in the courts. Indeed, the national judicial policy enjoins the courts to always encourage parties before the court to explore alternative dispute resolution procedures where appropriate. For us at the Benue State Customary Court of Appeal, seeing the need to partner with the ADR mechanism and encourage it, we have taken a step further as evidence in the case of Bahangave Oyojime against Ushankura and another. In the said case, the respondents as plaintiffs sued the appellant before the area court, claiming a portion of farmland. Before suing, the respondents had referred the dispute to the elders of the kindred for arbitration, who resolved the matter in favor of the respondents. The appellant appealed to the clan head, that's the next high level of the traditional arbitration, who decided in favor of the appellant. The respondents were dissatisfied with the decision and so sued the appellant before the trial area court, which awarded the land to the respondents. The appellant felt agreed with the decision of the trial court and appealed to the Benue State Customary Court of Appeal. The question that arose for resolution was whether it was right for the respondents to resort to judicial proceedings rather than exhaust the avenues available to them in traditional arbitration. In upholding the appeal, we heard as follows, and I quote, one would normally have expected the respondents to have appealed to the next high level of traditional arbitration. From our experience in these traditional arbitrations, such appeals go from the lowest level, which may be at sub-kindred level, to the highest level, which is the Chief Traditional Council. The instant case on appeal, the next level of appeal was the Te Okuna, the immediate level of traditional rulership. Rather than take that step, the respondents decided to sue. It is here that the issue of estoppel by conduct comes in. It cannot be validly disputed, and the parties hearing voluntarily submitted their dispute to the traditional arbitrators, the elders. Equally, the parties by their conduct must be deemed to have agreed that the decision by the arbitrators will be accepted as final and binding. Under chief customary law of traditional arbitration, any party who is not satisfied with the decision of a lower level arbitration appeals therefrom to the next higher level. So far, we have not, this decision has not been set aside. We are waiting for any of the litigants to take the case on appeal so that we'll know whether we are right or wrong. Improving efficiency in lower courts. Efficiency in lower courts can be improved by reducing the delays that often occur in the justice system. Many lower courts struggle with backlogs of cases, which delay justice for individuals involved in disputes. One way to tackle this problem is to hire more judicial officers to handle the increasing number of cases. By employing more magistrates and judges, courts can reduce the number of pending cases and speed up the judicial process. On the issue of delay of cases in court, it is germane to point out that the Constitution, in order to tackle this vexed issue, provides in section 294, subsection 1 as follows, and I quote, every court established under this Constitution shall deliver its decision in writing, not less than 90 days after the conclusion of evidence and final addresses, and furnish all parties to the cause of matter determined with duly authenticated copies of the decision within 7 days of the delivery thereof. I want us to know that several judicial officers who have breached this provision of the Constitution have been sanctioned by the NJC. Furthermore, states that have not adopted the provisions of the Administration of Criminal Justice Act 2015 are enjoined to do so in order to obviate delay in criminal trials. The objectives of the Act are laudable. It has come to engender speedy trials. By Section 396 of the Act, trials are to be conducted on a day-to-day basis. Where this is not possible, the court is expected to grant no more than 5 adjournments to each party, provided that the intervals between each adjournment shall not exceed 14 days. While it is impracticable to conclude a criminal proceeding after the parties have exhausted their 5 adjournments each, the interval between one adjournment to another shall not exceed 7 days. Costs may be awarded in order to discourage frivolous applications for adjournments, even though it is a criminal trial. Similarly, by Section 306 of the Act, the court is enjoined not to entertain applications for stay of criminal proceedings. All preliminary objections are made with the substantive case. In the case of Metu against Federal Republic of Nigeria, the Supreme Court upheld the provision in that section and held that Section 306 of the Act is not unconstitutional. It is unfortunate, however, that several states in the country are yet to adopt the provisions of this Act. They are therefore urged upon to do so mutatis mutandis, so that the objectives of the Act may be fully realized. Ensuring integrity and reducing corruption. One of the major challenges facing lower courts is corruption, as earlier stated. Cases of bribery and other unethical practices can damage the integrity of the court and erode public trust. To address this, strict rules and monitoring systems should be put in place to ensure transparency in handling of cases. The introduction of accountability measures, such as regular inspections and audits, will also help reduce corruption in the system. Judicial officers must be held to high ethical standards, and those found guilty of corruption should be punished accordingly. Encouraging integrity among judicial officers will go a long way in ensuring that justice is not sold to the highest bidder be delivered fairly to all citizens, regardless of their financial status. Judges of lower courts, and you should take note of this, should know that you are also expected to observe the Code of Conduct for Public Officers, which is set out under Part 1 of the 5th Schedule to the Constitution. Conclusion. The position of the Judiciary for Better Justice Delivery in Nigeria requires a comprehensive approach that addresses the systemic challenges facing the lower courts. By strengthening judicial independence, investing in infrastructure and resources, and enhancing the training and capacity of judicial officers, Nigeria can build a judiciary that is capable of upholding the rule of law and delivering justice efficiently and effectively. As Lord Denny once said, justice is the foundation of society. Without it, the structures of law and government crumble. In Nigeria, the lower courts play a pivotal role in maintaining this foundation. And by addressing the challenges they face, the country can ensure that justice is delivered to all its citizens. I thank you for listening.
Well, your worships and your honors, I told you that the paper is very rich. Indeed, learning makes a man, but reading and studying makes a complete man. As magistrates and judges of the area court and district courts, you must make reading, studying, knowledge one of the key factors in the dispensation of your duties. Now, the meat of a well-prepared and presented paper is in what? In the lively discussions that will follow it. That is the essence of a paper presentation. I told you the presenter comes with a very rich wealth of experience. I forgot to even inform you that my Lord was appointed in the year 2001 as a judge. 2001, that is about 23 years ago. I thought somebody should clap for that. It is not easy. And incidentally, that was even before I was appointed as a judge. My Lord, my senior, thank you. I was appointed in the year 2002, so a year after his appointment. Now, he rose immediately, at least by the year 2021, by the year 2015, he was already the president of the Customary Court of Appeal in Benue State. Now, let me mention this, and I'm mentioning it because it's very important and it's good to give honor to whom honor is due. My Lord today is the chairman of the Forum of Grand Qadis and presidents of Sharia and Customary Court of Appeal in Nigeria. That's a very heavy one. He shares all the presidents and the Grand Qadis, and I'm sure some of his colleagues are here with us. Let us therefore once again appreciate this great man who has so flawlessly presented his paper. With that done, I am not in the habit of summarizing what a good presenter has already presented. The only thing left is for discussion, questions, comments. And then, of course, my Lord, the President is ready to answer your question. So I throw the floor open now. If you have any comment, any observation on the paper or questions, please just indicate by raising your hand so that I can call you up to please have the floor. Yes, the floor is open. On the high table, do we have anybody who want to make a comment here among us here? Comment? No, let's start from the high table. And when we give them the lead, they will join. If you have any comment, yes, please let my.
The chairman of the session, the presenter, members of the high table, the participants. I have the order of the presenter that I should introduce myself. I'm the President, Customary Court of Appeal, Owerri, Imo State, and my name is Honorable Justice Okorie, VU. Well, I must start by commending the presenter for this erudite paper. And I would advise you, when you go home, make it a continuous research work, not only on the topic, other topics. I want to share my experiences as a magistrate. I was on the lower bench for 15 years. After serving at after brief practice, I joined the Ministry of Justice 1991. 93, I left Ministry of Justice, was appointed a magistrate from 1993 to 2008. What I observed is that if you are too liberal with your friends who are lawyers, they can put you in trouble. I stopped lawyers entering my chambers as a magistrate. When I caught one of them, he took money from his client to come and give me. He entered my chambers early morning, greeted me, asked me the journey from Owerri to Okigwe. Of course, I said fine. He asked me about my family. I said fine. He went out. Later, somebody called me and said, "Did he give me something?" I said, what do you mean by that? He said that the man took money from his client to give me. I said, okay. I had to call his attention. If it was the late Justice Ngozi Okpara of blessed memory that waded into the matter. If not, I was determined to report him to the disciplinary committee so they would rob him. Well, from that moment, I stopped allowing lawyers to come into my chambers. On one occasion, one lawyer wanted to see me. I said, no, wait. When I entered the courtroom, I called his attention and asked him to tell me what he wanted to discuss with me in the chambers. Of course, he refused. And I had the experience of the registrar. He complained that since I became the chief magistrate of Okigwe, he stopped roofing, continuing building his house. On one occasion, a litigant was in court. It was a landlord-tenant matter. So I saw the well-prepared claim. I asked the man, where was his lawyer? He said he had no lawyer. I said, who prepared this beautiful document? He did that is somewhere there behind me. I asked him to go and call the person who produced the paper. Behold, it was the chief registrar, or I don't know what they call the registrar. Onwe is late now. When he came out, I asked him to do the matter for the man. He was shaking. Well, what I have said, you have to be wary of your staff. First of all, you must be determined to be corrupt zero. Our people say that good name is better than what? Than what? You have to make you should be ambitious. You should aim at, after serving as a judge of a lower court, you should come to the lower bench, higher bench. And you can't come up over there when you are corrupt corrupt. It's for you to determine that you must be upright. Because the people outside are like mirrors watching you. The person that gives you, he will go out and say he has given you money. Your pass, it points at you. So please, guide yourself, guide your staff, guide your office. I think that will help to reduce this so much talked about corruption. Thank you very much.
Always guide yourself, be conscious. It's your own career that is on the line. If you desire to be upstairs, you must guide yourself jealously how you perform your work. And like my Lord the President has said, your staff is very key. You can't let them be and say, let them do their own. No, it's your court. They have to do what you want to be done. Any other from the high table here? Words of advice? Okay, my Lord, my students there.
Good morning, my lords, on this side of the hall. I want to once again commend the paper presenter, the moderator, the chairman of presidents. Incidentally, he's a great Akokite. We were in Unilag together, so we date back to 1982. He has said it all. And like the CGN was saying yesterday, most of us are products of the lower bench. I was also a product of the lower bench. So I know all the constraints. I know all the constraints for infrastructure, lack of training. Sometimes you are not given adequate recognition or visibility, all that. But you, like my Lord has said, and like it keeps resounding, you have to rise above it first in your mind, personally. You just make up your mind. What do I want to bring to this profession? How far do I want to go? So it becomes your own personal project. And no matter what, no matter the challenge, once you have that mindset, you will always feed your focus and you will treat every other challenge. I'm not saying the challenges are not there, but you will treat them as distractions that you must have. I'm sure you understand what I'm saying. I want to make emphasis on page 5, where my Lord relied most brilliantly on the Supreme Court case of Banda versus Telepa, Nigeria Limited, and what our former CJN said. I mean, because of time, I don't need to read it out. But what they're trying to say is that you should not allow any litigant to take a court to ransom. And I will extend it by saying that you are also legally qualified career judicial officers. And in fact, the administration of justice starts from your courts. The perception, the foundation is from your courts. So even your colleagues, I mean, I'm now saying lawyers, don't let them throw you off board. Sometimes it is those that are even very friendly with you that will want to throw you off board, that will want to bring frivolous applications that do not exist in any of the precedents. You must resist it. And please, no matter the exposure in this legal profession, we're still all learning. there is, law is constantly evolving. So you do your research, but don't be afraid to ask questions from all these people. Technology has made it easier. You can call, you can send a message, you can even do a voice note. If you do not know what really you want to give, quickly, you can rise up. I'm not saying you should adjourn for 3 months just to give a bench ruling. You can quickly send a voice note to somebody that you know, even if it's not within the vicinity. Technology has allowed that. So please make use of technology. Have a very positive mindset, and also don't be averse to mentorship. Mentorship eventually metamorphoses into sponsorship. And what I mean by that is that some of us on this side of the table, when we see that you are fit for higher bench, we will not only mentor, but we will sponsor. God help all of us.
We will now take just one or two and then round up. Yes, please let him give him the mic. Thank you. Make them briefly so that we can just round up.
Lord, the moderator, Lord, the paper presenter. My name is Collins Godfrey Ali. I'm a chief magistrate from Rivers State. My Lord, I want to start by thanking you for that well-prepared and delivered paper. We are pleased with your presentation, and I'm sure it's going to help every one of us. Lord, my reason for getting up is in one of the advices you gave, when it has to do with interlocutory application and how it causes delay. Lord said we should take it and proceed. Lord, I'm afraid that taking it and proceed may result in appeal. My experience is that when I see such applications, I will advise lawyers in a very short ruling that this application will be taken at the end of the proceedings alongside the final written address. And with that, I'm always home and dry. They abide and then the matter progresses. At the end, the preliminary objection or interlocutory application is taken in course of the judgment first before one now proceeds to the substantive matter. That will assist rather than taking it. Taking it means that time begins to run within which ruling should be delivered. That is my comment on that. Lord, I want to also lend my voice strongly on the law that is pending in the National Assembly to take away the power of appointment, removal, and then financing from the NJC to the state government. That, I think, is ill-intended. It's ill-intended because the little we see with respect to appointment of judges via recommendation by JSC, you see that the state governors have overbearing influence on the State Judicial Service Commission during those exercises. And so one wonders what will happen if you now give the power to remove, appoint, and maybe finance to the state government. That would be suicidal and would not be good for the judiciary at all. Lastly, on the issue of delay, I want to share our experience in Rivers State. The Lord, the Chief Judge of Rivers State, Honorable Justice Simeon Amadi, have issued quite a lot of practice direction to curb delays in trial. In fact, in Rivers State, we have small claims courts that handles matters not above 50 million naira claim, and the trial by the practice direction ends within 60 days. That has helped in civil matters. We also have practice direction that requires the magistrate to, in some cases, refer our matters to the multi-door courthouse, where amicable settlements are reached, finally return back to court to enter consent judgment. That is our experiences in Rivers State, and it has helped us to cope delay in civil matters at the magistrate court. Thank you once again, the Lord, for the
Thank
papers.
you. I think because the topic is very important for your worships and your honor, we want to ensure that we don't cut it short. We want to have a robust discussion. So what we want to do now is that the presenter will answer or respond to some of the issues raised now, and then I'll plead with you to release him, because right now, supposed to be in a meeting with the Board of Governors of the NGI, presided over by the chairman, which is the Chief Justice of this country. And so we don't want him to miss on that meeting, but we also don't want you to miss in why you came all the way from wherever you come from to Abuja. So he will take a response and then he will go, and then the discussion will go on. I have on the high table very great minds here which can also respond to you. Is that okay? Thank you. My Lord, you can respond and then take a leave.
Thank you, my PJ. Most of the interventions were by way of contributions. I think the only issue there is that of interlocutory applications. It's not every interlocutory application that you defy the ruling. Some of them, they require on-the-spot judgment, bench ruling. It's not every interlocutory application. But see, some of those applications that are brought principally to forestall the trial so that the trial will not go on. Some lawyers, once they get the brief, they don't want it to end at all. They don't want to end the eternity because I don't know what it is. So you should be able to differentiate some of those applications, because some applications are very innocuous. Just give a bench ruling there. There's some of them that you sense that are meant to delay proceedings. Be very cautious with them. Whether they say you don't have jurisdiction, once they say they don't have, once you rule that you don't have jurisdiction, they'll take it up to the Supreme Court. Just like the case I cited, that was exactly what happened. They took it up to the Supreme Court, and they will file application to stay proceedings so that you cannot go on. So such ones, to say, okay, make the application, because issue of jurisdiction can be raised at any time. Even if you don't raise it in the court of trial, you can raise it in the Supreme Court. So those ones, you should be cautious. So that is what I was talking about. I don't know whether that's clear. Okay. So thank you very much. Like the PJ is very, very capable, able, and willing, and I'll leave you with him. Thank you very much. God bless you all.
Let's give a round of applause for our president of the customary court of appeal, Benue State, as he takes his leave. My Lord, thank you so much. It has been our pleasure. Thank you so much. Thank you so much. The conference goes on. Live was a vacuum. So we will fill it in and go on. Now, your worship and your honors is very, very important and crucial for me as a person. First and foremost, we need to retrospect, check ourselves, introspect, see whether do you have a call? Do you have a call for judging? Do you have a call for judging? This work becomes difficult if you don't have a call and somebody brings you there. You won't enjoy it. Yes, sir. Take it from. Well, all those who are from Ekiti Judiciary, you are president, Says, is it president? The president of the Customary Court of Appeal wants your attention, but I think tell her she has to hang on. My people are studying. I don't want to disorganize this conference, but if you are here, please kindly go out and meet your president. Kindly go out and then come back immediately. So like I'm saying now, when you talk about appointments, many a times we all forget that we are in a federation. We are not in a unitary system of government. We are in a federal republic of Nigeria. And what is the key attribute of a federation? What is the key? The components units come together, okay, to form the federation. Those component units, they do not surrender their own independence over some of the affairs of their state. They do not. They say if they want to also be for NJC to appoint, fair and cool. But we must look at the principles of federalism and see what the evolution of power means between the federal central system and the federating unit. Having said that, please, the floor is now open again. Oh, I love this now. I'm seeing so many hands. See, when you get up, please introduce yourself, so that we know who you are, and then go straight to the point so that your colleagues will benefit. Yes, please bring the mic to him. Quickly, quickly. Now you know the presenter is away, so you are both the questioner and the answerer. So ensure that you make us understand what you are arguing. God bless you.
Thank you, my Lord. First of all, my name is Emmanuel Jato Samaila, Upper Customary Court Judge, Kafanchan in Kaduna State. I wish to commend my Lord for the presentation of the very incisive and inspiring paper, which was well delivered. I would appreciate if my Lord were here to amplify on the reasoning or his reasoning for his suggestion that in the constitutional amendment, the judges to be captured as judicial officers should be those who are lawyers only. I would reason that it will be fairer if the law allows a non-lawyer to be appointed as a judge and he performs such duties, then he should be entitled to all the perquisites of that office. Unless if there are other reasons for their exclusion. Well, even if they are to be excluded, it will be fairer if a part of the entitlement is given to them, maybe not all, at least to distinguish that the other persons, the lawyers, have an extra qualification. But from reality and practice, we understand that there are some judges of the lower courts who are non-lawyers that have performed so excellently and are men of integrity. And we think that such judges should be entitled to all the perquisites of office applicable or available to a lower court judge, whether he's a lawyer or a non-lawyer. Thank you very much.
Any other comment? Yes, I can see. Yes, ma'am. Please, as they speak, you note it too. When we finish, all of us will also discuss what they are saying and see the practicability of some of these things. So note it now. The president, the presider, the presenter of the paper is not here. So note what they are saying. Yes, go on, ma'am.
Yes, permit me to stand on existing protocols. I wish to commend the paper presenter. My name is Hasia Yunus Anyako from Adamawa State. So my question is, we have made a very good presentation, and the presentation is, we all know, is about repositioning the judiciary. So do we have any plans on ground to reposition the lower courts? Like, we have identified that there are gaps, existing gaps, there are no capacity development, enough adequate capacity development plans for magistrates. There are no adequate resources. Do we have a committee that is responsible for repositioning the lower courts? So this is just my question. I know 70% has to do with us as magistrates, but also there's a system on ground. So I believe we all have a role to play in this. Thank you.
Thank you. Please, the communique committee, this question is very important. So you note it so that we can send it to the relevant authorities that what is there or the plans for repositioning of the lower, judges is very key, so that she's taking it away from just talking. Am I right? Into taking actions that could reposition this court. And for me, that is key. That is the most important thing. After all the talks, what do we do to make the lower judges confident, proud, glad that they are there until when they get promoted, and also seamless form of promotion for people who have performed at that level? Do I understand you to this? What you mean? Communique committee, please take note. We will send it to the NGI, and then the NGI knows how to take it up. Yes, next question. Yes, give it to that man. Yes, quickly, your name, and then.
Thank you very much, my lord. My lord's on the high table. My name is Shekoni Oluwadamilola from the Ondo State Judiciary. My question is from page 29 from the paper, and it's on the Administration of Criminal Justice Act. Now, my state has domesticated the act. We now have the Administration of Criminal Justice Law of Ondo State. Now, section 306 of the act says, no stay shall be entertained. No stay of proceedings shall be entertained. Now, when it was being domesticated in Ondo State, the lawmakers, in their wisdom, removed that portion. So that portion is not in our own law. Now, my question is, I have a case presently in my court. Fortunately, it started in my August court here, sitting behind me. It started in 2018. And yes, my lord, it started in 2018. She presided over the case, and it got to a certain level. I don't know what really happened. I think, okay, she was transferred. Then another magistrate took over the case. Now, when the prosecution closed their case, they moved a no case submission, and it was dismissed. Now, they appealed to the High Court. The High Court also dismissed the appeal. Now they went to the Court of Appeal. In the course of that, they wrote a petition against the magistrate, and it was, the magistrate was ordered to remit the case file back. Now I took over the case. The case has gotten to no case submission again, and now they have appealed the no case submission. Now, the problem I have is there is a stay of proceedings before me, and there's the substantive appeal at the High Court. Now, I cannot do anything due to the stay of proceedings before the High Court. Now, the problem is that it has taken 2 years. The High Court judge is yet to take that application and even the substantive appeal. This is a 2018 case. My Lord, help me. Thank you very much.
Yes, it's noted, but you know, we can't do away with procedures. These procedures are meant to help check both us and the parties to ensure that all of us go in accordance with the law. You know, every system has its advantage and also disadvantages. But I think the High Court of that state should be able to decide a no-case submission matter in less than a year, if not 6 months. What does it take? They file the briefs and you take it and you decide, so that the magistrate will know what to do, because you cannot go on and be trying a man when you don't know the possible outcome of his appeal. And you know, the law of France are the situation where a man has no case to answer, but he is made to defend himself over an allegation that he has no case to answer. So this is a serious constitutional issue. I hope that the judges at the High Court too also will, live up to, expectations, so that they don't frustrate you. You know, some states did not put this stay of proceedings, and it may be for reasonable or good cause. Other states might say that, okay, there have been no stay of proceedings. But if there is no stay of proceedings and you go all the way, convict a man who has not even committed any offense, and the High Court releases him, what will you gain? The first time I condemned people to death, I went into my house and asked God that if I am wrong, let them discharge them at the Court of Appeal. That was my prayer, because we will all be accountable someday. All this power we're exercising, all these judgments we are giving, the judger will judge us one day. So be careful how you judge. Be careful how you use this power. So my brother, you wait. When the High Court gives its decision, if they say he has no case to answer, your matter is over. He goes. If they say he has a case to answer, he will return to you. Face other ones that are before you. I know you have so many more cases. Yes, any other discussion? Any other one? Yes, please give it to the gentleman there.
Good day, sir. My name is Ibrahim Sani, Magistrate Judge from Niger State. My concern here is when it comes to the issue of punishment of judges of the lower court, who are referred as also judicial officers by way of dealing with us in terms of code of conduct. But when it comes to remuneration, welfare packages, we are not seen as one. So I think it is desirable for the committee to look into the matter, especially in terms of amendment of the Constitution, if there is need to that effect, so that we should be encouraged and also motivated. Then in terms of security too, which is also should be part of our packages too, some of us leave our house with the fear that after leaving home, our family will be attacked. And as we travel, especially places like Niger State, where the landmarks is very wide, where you can travel for over 150 kilometers to get to your court. And again, issue of banditry issues that you have to confirm whether the road is clear or not, to the extent that some of us need to disguise ourselves as either farmers going to farm to get to our court, and even coming back again is the same scenario.
Please, I don't get that. You used to do what?
We need to disguise ourselves, wearing big babariga to look too old, so that you should get to your court safely. And when coming back, you do the same thing. So in terms of security also, we need security men who can also guide us. We don't even have policemen following us. So it's risky all through the life. So it is not encouraging and we need motivation.
You don't have policemen following you?
No, I don't have any. So that also affects in terms of delivery of cases within short period of time, because you have to be very sure whether the road is clear or not before you can even proceed on your journey to and fro. Thank you, sir.
Yes, I think this has to do with the condition of service for the lower, bench. Well, I know that in those days when we joined the bar, magistrates don't even need to ask for police. Policemen are even looking for them to work with them. It was compulsory. I mean, how can a magistrate work without a police protection? You are closer to the grassroots. You are closer to the people who sometimes can be very irrational. So you deserve to be protected. But I think these are administrative duties that each of the states, the chief judge, who is a proactive judge, should be able to ensure that these magistrates are protected. It's very compulsory. It's compulsory because you work at the far-flung rural areas. You sit in like district courts. I mean, I did my youth service in Kwara State. I went to district courts in Goloko, Dekina, all far-flung places where I know jurisdiction in education is almost to the barest, minimal level, but you need to be protected. Okay, you need to be protected. But another thing I'll tell you before I take other questions is that please, the position you occupy is very, very, very important. Don't allow anybody to belittle it. Not even a judge. Nobody. Because you are the first point of contact with the society for this judiciary we are talking about. If you do well, we will take the praise with you without even working with you, but the praise will also come to the people at the higher level. And so please, I beg you, at the season when you are here, be happy and be committed in the fullness of time. Some of you are occupying position as Chief Justice of this country. Am I talking to somebody? They move from the magistracy. So there is nothing to bother yourself. It's all about changes and time and seasons. I thought I'm talking to somebody. Your season will come. Your time will come. But be committed to this work. If you are not good in the little things the Lord has been able to give to you, you may not be good in the bigger things. And the bigger things may not even come. In terms of remuneration, both judges and magistrates, all of us were earning abysmally very low. Until recently, we have been blessed at a higher level with salaries that can take us home. It is my prayer that soon and very soon, you too will be blessed. And your salary will take you home. Me, I'm so fulfilled now with this new salary. In fact, I can even